Thank you for clicking on our informative surveying videos. Through our property surveying channel, we aim to combat and address some of the more complicated and tricky parts of property surveying that we undertake here at Stokemont. One of the services we provide on a regular basis is license for alterations to both freeholders and leaseholders alike. License for alterations come into play if a leaseholder of a property, also commonly referred to as the tenant, is planning on undertaking alteration works to their property. Commonly, these works are changing floor coverings. Changing the property floor coverings will often be deemed an alteration and will require a license from the freeholder. This is likely to only apply if carpets are being changed to hard surfaces, with requirements such as sound deadening underlay, acoustic testing and waterproof barriers, all potential freeholder conditions. Changing kitchen and bathroom location. Changing the location of a kitchen or bathroom or adding new ones is often deemed an alteration and will require a license from the freeholder, much like changing floor coverings. Requirements such as sound deadening underlay, acoustic testing and waterproof barriers are all potential freeholder conditions. There could also be service certificates or drainage assessments required. Alterations to services. Alterations to services, including water, gas and electricity, will likely all require freeholder consent via a license for alteration. Freeholder conditions for granting the license could be contractual insurance, safety certificates, building regulations sign-offs and potentially surveyor inspection. Layout changes. Changes to a layout, both structural and non-structural, will likely require freeholder consent via a license for alteration. Freeholder conditions for granting the license could be contractual insurance, surveyor inspections, building regulations sign-offs and structural engineer input. Window changes. Changes to windows will require the freeholder's consent and will be dealt with under the lease's alterations clause. Freeholder conditions could be contractual insurance, method statements, temporary support information, fencer certificates and temporary access requirements. Under the terms of their lease, the leaseholder planning on undertaking any of these works will require consent and sign-off from their freeholder, also commonly referred to as the landlord. A landlord's consent is very much dependent upon the type of leasehold alterations covenant and clause that is in place and wording in the lease itself. Generally speaking, there are going to be three variations or types of leasehold alterations clauses that are prevalent throughout all leases in England and Wales. Fully qualified covenant, qualified covenant, absolute covenant. We're now going to be taking a look at these leasehold alterations covenants in order to best advise you so you're fully aware as to what type of alterations covenant is set out within your lease. Fully qualified covenant. The first leaseholder alteration we're going to be looking at is a fully qualified covenant. This is the most favourable type of alterations covenant a leaseholder can find within their lease. Essentially, this alterations covenant means the leaseholder will be able to undertake their proposed alterations work to their demise, flat or property, and importantly, the freeholder is not going to be able to unreasonably refuse or withhold consent for a leaseholder's proposed works. In layman's terms, this effectively means that as long as the leaseholder goes through the necessary procedures and protocols required, which usually means providing their freeholder with information in respect of the works from a legal perspective, the freeholder cannot refuse the leaseholder's proposed work and is duty-bound to provide their consent. As a leaseholder, this is going to be the best possible outcome that your lease wording can contain. If you were to compare this to a traffic light system, this would very much be a green light. Qualified covenant. A qualified covenant is similar to a fully qualified covenant. However, importantly, the wording setting out that the freeholder cannot unreasonably withhold their consent will be omitted. From a legal perspective, this means the freeholder has the decision and control to grant a license for alterations at their disposal. The freeholder can not only decide if they want to allow the leaseholder to undertake the works, they can also stipulate any requirements, provisions, premiums or other matters governing that consent. Qualified covenants are a tricky one for leaseholders to get past. In many cases, freeholders will take legal advice from solicitors or professional advice from chartered surveyors, with such advice setting out that it is conventionally and actually quite normal for freeholders to request and charge a licence premium, payment or cost in order for a leaseholder to be granted a licence for alterations. Again, in layman's terms, this effectively means the freeholder can legally and rightfully charge a fee in order to grant a leaseholder their written and statutory consent to progress their progressed works to their demise, flat or property. This can often come as a shock to leaseholders as they'll be unprepared for this, meaning they can find themselves having to dig further into their pockets to cover the proposed cost of the works. In some cases, the works no longer proving to be economically viable and significantly thwarting their plans. If you were to compare this to a traffic light, this would very much be orange or an amber outcome. If you're unlucky enough to have a qualified covenant within your lease, here at Stokemont we would recommend that you take advice sooner rather than later, and furthermore we would advise that you do not incur too much cost in respect of surveyors, architects or structural engineers fees, as ultimately you could go through all the procedures in the best possible manner only for your freeholder to refuse consent or provide a licence for alterations with a significant financial level attached. Absolute covenant. The final leasehold alterations covenant that we're going to look at is an absolute alterations covenant. An absolute alterations covenant is by its nature highly restrictive. In essence, the wording of the lease will set out that the leaseholder does not have the legal right to undertake alteration works to their demise, flat or property. Again, this can come as a significant surprise to many leaseholders, as they will rightfully consider their property theirs and will want to have free rein over any creative design and alterations they have in mind. That being said, an absolute covenant is nonetheless binding. This means a leaseholder will have to comply with the alterations covenant and in all likelihood are going to have to scrap the idea of any planned alterations. An absolute covenant is also not one that freeholders are likely to negotiate, discuss or entertain the idea of deviating from the wording of the lease. Comparing this to a traffic light, as you can imagine, this is very much going to be a red light. Recent case law of Duval versus Randolph Crescent has significantly changed the way in which freeholders view alterations covenants and in particular absolute covenants. This case law is very much a bombshell to those lessees who have an absolute covenant within their lease, effectively meaning very few, if any, freeholders are now likely to entertain any discussions on alterations when there is an absolute covenant in place within a lease. Here at Stokemont, we assist both freeholders and leaseholders alike with their licence for alterations requirements. We have built up a tried and tested protocol for best handling licence for alterations procedures, and if you would like to discuss your licence for alterations options with our team of experienced and qualified RICS registered surveyors, please feel free to give us a call today and we'll be more than happy to assist and advise you. A service that we happily provide here at Stokemont is the opportunity for a leaseholder or freeholder to send in their lease for one of our RICS registered surveyors to review and confirm what type of alterations covenant is in place. There is no cost for this service, the premise being that it will best advise the freeholder or leaseholder, ensuring the necessary advice is given at that juncture. If you would like to take us up on this offer, please get in touch via the contact page of our website, providing the following: a copy of the lease, plans for the proposed works. However, if these are not available, you can always give us a short description of them. We will then review the lease and plans and ping over some advice in this regard. Our surveyors will be more than happy to assist and advise.